Hey, nice to have you with us. Mansfield today on a Tuesday, and that means it's time to take a look at the law with our resident advocate, Lance Brogden. Lance?
Hey, Jim, good afternoon. Good to see you, mate.
Listen, I may be wrong here, but this is a perception that I'm getting, and I think it's based on, there are so many legal cases that are being drawn out, and they're going from a Supreme Court to a Supreme Court of Appeal to a Constitutional Court, and then in some cases even it's being thrown back to the High Court as well. There seems to be a sort of frustration. Is it just my perception, or is your average South African starting to lose a bit of trust in the legal system itself, Lance?
Jeremy, I think that perception is correct. And I think we need to put it in context. I've had a number of calls as well, and people have sent me emails saying, it's nice to hear you talk about this stuff, but we don't trust the legal system. So we also ask ourselves, why is that perception there? And I think there are a couple of things. One, it is perceived to be expensive, and it is an expensive exercise. Litigation is expensive. And the man in the street doesn't understand why it has to be. Secondly, it is slow. There are postponement upon postponement. It doesn't get postponed for a day or two. It gets postponed for 3 months or 6 months. So there's a lot of frustration behind it, but there is a lot of rationale behind it. And then there's one more thing. I put it this way. Each of the parties believes they have the upper side. And a colleague of ours, you know him, Wynand Bester, was saying to me this morning, if you sit in chambers and you look behind it, all those reported court cases, there was a plaintiff and there was a defendant. And one of them lost in those reported cases. Those reported cases are it's a minuscule amount of all the cases that go through court. So, yep, it's a perception, but we have to put it in context.
So, how should we be looking at the legal system so we have that context?
Okay, I think that's the important thing. So my statement a minute ago was almost against the legal process. I'm not against it. So let's say there are 4 areas to look at. The one is hardcore policing, traffic officers. That part of it, yeah, we've had a couple of weeks where we discussed this. It is concerning about the training and bribery and so on, and the slowness and the dockets getting lost. But now I'm talking about more in civil court. So what do we have there? First, we have the law and the legal process. The law isn't a switch right and wrong. I wish it was codified like that, but it's not that simple. It has to be interpreted. And the process is not about making sure one person wins. It's about both parties being given equal chance to represent themselves or be represented and go through a process which includes things like the summons, discovery, mediation in some matters, pre-trial. So the law is about that fairness to try and get an equitable result. The third area is very clearly is the representation. Lawyers, the advocates, they themselves have certain codes that they follow, and they have to be fair to both sides to get a result. And then here's the problem one, is you and I, the parties in the matter. There, for a start, one comes in, one believes one's got it taped down, has everything organized, and only your case will win. And there are reasons why that's not the case.
Where does it go wrong for the man in the street then?
Well, firstly, I think most importantly is the man in the street is not patient. Okay, he's not, and I understand it. He wants a result today, but because of what I said a few minutes ago, is it has to go through a process where it's equitable and all the facts are on the table. I think further than that, the man in the street, in many cases, only tells his legal representatives what he or she wants them to hear. Doesn't disclose it all, and often doesn't believe it's necessary to disclose it all because they've got a tape, they know what's going on. 3 is the man in the street is almost, when they enter this process, believes they are going to win it. And it's not that simple. It's not a case of just winning and losing. We have to go through the process. The costs are frustrating. But remember on the costs, I've told you before, you can go and speak about it. You can negotiate it. And if you really think you know more than your representative, do it yourself. And some people do think they know more. I got shouted at again this morning by a client saying to me, but this is what I want and she's unreasonable. And well, that's fine then. You know, if you don't want to take my advice, then you don't have to. Please feel free to do it your own. Yeah.
But there are levels of frustration here, Lance. I mean, you must have examples of what frustrates people.
Very much so. Person would say, in the contract that I've got in front of me, is here's my rights. But once again, did that person read the entire contract? And when it's exposed, saying, hang on, there are many parts to it, and this refers to another clause, etc. Here's another big one. So, Jem, you win a matter. You win the matter and you win a costs order in your favor. You still then got to go and get those costs in. And often by then, that company's either been liquidated, doesn't exist, the other party doesn't have the means, they have to be sequestrated. If you go into liquidation, you might have to pay in at the end of the day to the liquidation costs. The frustration of winning, and they are called hollow victories. So be very careful. Another frustration is sitting with your counsel and say, what are my chances of winning the case? The job of your representative is not to tell you the chance of winning the case, it's to show you the risks of going ahead. And the fact that it's going down a route is you might not get everything you want. And of course, the big frustration is just slow. Postponement, postponement. It's not for tomorrow, it's for 3 months' time, it's for 6 months' time. The frustrations are massive and they're real. But that is the only way justice can be properly executed without just summary trying everybody and have free flow out there and carte blanche.
Okay, so then where do we go from here?
Okay, rule 1.
Yeah.
Don't break the law.
Yes.
Don't break the law. If you've had 1 beer, you can drive home. If you've had 2, you can't drive home. Okay, we start there because we've all had friends, and some of us in this discussion here, luckily not around this table, but have been stopped, breathalyzed, blood taken, incarcerated for a night or 2. Yet you broke the law, okay? You were out of line. Don't drive recklessly. There's a speed limit. Don't go over the speed limit. I'm not telling you how to drive, and we're all guilty of it. But first thing is don't break the law. Secondly, if you're going to an agreement, read it in detail, every part of it. Make sure you understand it. Sit with the other party and go by line, by line, by line. Okay? And make sure you both understand it. And if your agreements are complex agreements, feel free to put examples. And a quick one, if you have a rent to buy agreement on a property or a company, you're going to buy the shares in time, put a model. So you might discuss the calculation of the value in the future. But go ahead and do an example. Use 1 Rand, 2 Rand, 3 Rand and show the example. The next thing, don't sign surety. If you can avoid signing surety, don't sign surety. If you have the agreement in front of you, scratch out the surety. If they don't want to do the deal, they don't want to do the deal with you. Because things happen. COVID happens. And then the next thing, there's no excuses. Don't blame COVID. Don't blame somebody didn't pay me and I can't pay you. Please, guys, be very, very careful. And lastly, and I think this relates to agreements again, a lot of the trauma and emotion is in family law. It's about divorce. The original source agreement when you get married, your ANC, sit down and write it as if you're going to get divorced. If you're doing an agreement, a complex agreement, write it with the expectation that something is going to go awry. And Jem, I think that's what it's about. Don't break the law. Take responsibility for what you sign. Avoid signing surety if you can. If you can, I know there are issues. And the other thing is, don't blame somebody else. You bought a car, you bought it through the bank, your prepayment is 3,500 Rand a month. If you don't pay, the bank is right to come after you. Okay, and you can go and tell your attorney what a bunch of bastards they are, but you had that agreement. Agreements are agreements.
We'll agree to differ.
Indeed. And that's why we go through the process and we do discovery and we go to mediation and we go to pre-trial. We do that because we differ. And, try and settle. 99% of cases, eventually when it gets there and the costs are seen, don't go into this to think I want to win all round. I mentioned this once before. The best settlements are where both parties feel they lost a little bit. They're the best settlements. You don't want one party thinking, I've got it all and screw the rest. That's not what we do.
Lance Brogden, thank you very much again for your wise legal advice.
Thanks, Jim. Thanks for having me with you on the show. I really enjoy it. Thank you.
Now you see you're lying.
Yeah, my lips moved. That's the lawyer's lying.
We'll catch you again next week, Lance. And we'll catch you again on The Legal Show next week, right here on Mansfield Today. Thank you for watching. Goodbye.